Good morning, everybody to Europe. Good afternoon, everybody in China. And welcome to the USME webinar series. Topic of today's webinar is labor regulation. But before we move directly to the topic, I would like to firstly introduce USME Center in Beijing. USME Center in Beijing is a project funded by the European Union, and its main purpose is to assist European SMEs to export to China and establish, develop and maintain commercial activities in the Chinese market. I hope that many of you have already contacted us, but for those who are not familiar with our services, here are the services which we are able to provide to our clients. We have deep expertise in the business development, legal and tax advice, standards and conformity, and HR and training. USME Center provides information and advice via publishing documentation. Up to date, we have published more than 80 publications, case studies, reports, and guidelines. We provide answers to the inquiries either via email or via our website, as well as the face-to-face consultation. We do the trainings through the Europe and in China, and as today we provide our services via the webinars. In addition to the information and advice, we have a wide range of the support services like hot desking. So if you are interested to spend some time in the Beijing, you have a business meetings, you can stay for a few hours or a couple of weeks with us, and you can share the offices with us. We as well provide access to the several databases like service providers database, publications database, and updated international fairs and exhibition databases. Recently, we have launched a new toolkit which we call Are You Ready for China?, which is a short introduction to the doing business in China, covering topics like market entry to China, knowing your partner, information about the opportunities and the challenges in China, and there is a special volume for those who are interested in exporting of goods, services, or technology to China. Before we move today to the topic of our webinar, I would like just to remind you that we are able to answer your questions online. So if you have any time during the presentation question, please send it to us through the questions panel, which you can see on your screen, and we will address your questions either at the end of the seminar or we will get back to you later by email. So now to the topic of our today's webinar. It is about the labor relations. Unfortunately, labor relations are at the fringe of interest of foreign investors, and they should not be. In the recent years, labor legislation in China has developed noticeably and very often in a way to support the weaker part of the relation, employee. Today we focus on two important documents which govern employment relationship on the contract, labor contract, and Employee Handbook. And in connection to that, we will put light on a few topics which deserve more attention as they are a source of usual misunderstanding between employer and employee. And now it's time to welcome our special guest, expert who closely cooperate with the USME Center, and it's Mrs. Lily Cao. So warmly welcome. Mrs. Cao is a senior legal manager at the Ecovitz at the Beijing in China. She is a qualified lawyer has over 10 years of multinational experience advising companies with foreign direct investment, mergers and acquisition transactions, contract drafting and reviewing. And what is especially important for today, she's expert in labor-related consulting. So let me welcome her once again and pass the floor to her.
Thanks, Ludmila, very much, and welcome to join our webinar today about these labor issues. And today in our webinar, we will focus on the following key points, which are the importance of written labor contract. Next is the overview on working hours schemes. And then we will give some explanations on the practicality of Employee Handbook. And also in the Employee Handbook, the staff performance assessment is a very important part. And also for some senior management people, we will suggest to use the confidentiality and non-competition clause in our Employee Handbook. And the most important, we would like to share with you about the termination, because lots of the employer here in China has kind of thinking that it's very difficult for a termination. So in today's webinar, we would like to share our knowledge and our practical experience on this topic. Now we will have our first poll today. So please look at our question and give your answers.
Just give me a second to launch the first poll. And our first question is about the employer, whether the employer needs to sign a written contract. And the options we are giving to you is yes, no, or yes, but with the exception of the part-time contract. So we will give you a few more seconds to answer. Now I'm going to close the poll and we'll share with you the results. Lily, would you like to comment?
Okay, now we have the results here. 75% tick yes, and only 4% tick no, and 21% ticks yes with an exception of part-time contract. Okay?
So what is the correct answer?
The correct answer will be C. Yes, a written contract will be required. However, the part-time contract will be an exception, which means for the part-time contract, it's not necessary to have a written contract. The oral contract is also fine. Okay, now I would like to explain further about this issue. Under the new labor contract law, actually we have this kind of labor contract. Normally, I think everybody will know, normally they are the fixed-term contract, indefinite contract. We also call it open-ended contract. And also, we have the contract with a term to finish a specific project. And in addition to these three, we also have the part-time employment contract. So in this slide, you can see, okay, the written labor contract is compulsory in general. However, the part-time employment contract is an exception. So our next question is, if I didn't sign a written labor contract, what the risks there will be? Normally, the risks is depending on how long the written labor contract are not signed. So here you can see there are three periods. One is within 1 month after starting work. The second one is over 1 month, but no more than 1 year. And the last one is no written contract signed even over 1 year as of the starting work date. Okay, for the first one, within 1 month after starting work, if this is the employer refused to sign the labor contract, then the employer has to pay a double pay to the employee. However, if employer requests to sign the labor contract, but the employee said, no, I don't want to sign with you, Under these circumstances, the employer has a right to terminate the contract by giving a written notice to the employee and without paying any severance pay. So under the over 1 month but no more than 1 year after starting work, so if this is caused by the employer, then the employer will pay both double pay and the severance payment. So if there's no written contract over 1 year as of starting work, also due to employer's fault, under these circumstances, an open-ended contract, or we can say an indefinite contract will be deemed as concluded, and a written contract also required to be signed immediately. And at the same time, if this is not signed, then the employer also required to pay the double rate of salary until the written contract is signed. So just now, we shared with everyone here a written labor contract is required in most cases. So the next one is, what kind of articles or clauses should I need to put into our labor contract? So in China, we have mandatory clauses and also we have the freely agreed clauses. For the mandatory clauses, which means the clauses we are showing to you next must be incorporated into the labor contract. The first one is the name, address of both parties, name of the legal representative, as well as the ID card number of the employee. Next is the term of the contract. You must specify this is a fixed one or is an indefinite one. If it's a fixed one, then how long is the labor contract. Next one, you have to specify the work content and the location, and the working time and leaves, and remuneration for the employee, social insurance for the employee, and labor protection and occupational protection that the employer can provide for the employee.
Lily, I have a question, practical question. What would happen if employer forgot about some of these? What will happen if the employer forgot of some of these mandatory provisions? Is there any punishment in terms of the penalty?
Okay, this is a very good question. Generally speaking, under the Chinese laws, there are not financial penalty for the employers if the employer does not input the mandatory clauses. However, if this kind of thing is exposed to the Labor Bureau in charge, then the Labor Bureau will ask you to correct your action, which means you must put all the mandatory clauses into your labor contract. In addition to this, if you didn't put the mandatory clauses, and also you caused some damages to your employees, then the employer should be liable for the damages caused to the employee.
Mm-hmm.
Okay?
Thank you very much. And then we move to the working hours and the systems.
Yeah, so just now we understand what kind of mandatory clauses we should put there in, and then the next slides we will share with you focusing on the working systems and the rest for the employees. So firstly, it's better for us to understand how many working hour systems in China, because the different working hour systems will affect the calculation of the overtime payment. And also for the different companies engaged in the different specific business scope, or for the different positions of the employees, there should be different working hour system to apply. So generally speaking, there are three kinds of the working hour system. The first one, and also is a commonly used one, we call it standard working hour system. Normally, it's like the office workers who should be sitting in the office always, and these kind of employees should adopt the standard working hour system. the characters for this system is, okay, the employee should work 8 hours per day, 44 hours per week, and the employer must guarantee the employee can take 1 day off per week. And also for adjustments for the business needs is possible. The last one is for the OT, overtime. Normally, it should be no more than 3 hours per day and no more than 36 hours per month. However, there should be some exceptions if the employer has evidence to prove that it did need the employee to do the OTs. It can apply with the labor authority and get their approval first, and then you can prolong the OT. Otherwise, any prolonged OT hours existing the statutory OT hours here will be deemed as illegal. And the next one is comprehensive working hour system. Normally, this working hour system applies to those employers whose business has kind of seasonal characteristics, like the, for example, like you always use the workers to do the shifts. And then it's not so easy to ask employees to follow the 8-hour working day per day. So under these circumstances, you can apply for the comprehensive working hour system. And this working hour normally is calculated based on a specific period, like a week or a month or a quarter or a year, subject to the employer choice and also the approval from the labor authority in charge. However, even you choose the calculation basis as the week or month, you have to guarantee in average the employee shall also work no more than 8 hours per day and no more than 44 hours per week. Otherwise, the OT, liability of the employer, may trigger. The last one is the non-fixed working hour systems. This working hour system normally applies to those senior management or the salespeople. For this kind of people, it's not required to sitting in the office all days because they need to go out to the office for business purpose or for selling purpose. So, but there's one thing I should let you know, that for the comprehensive working hour system and non-fixed working hour system, you must get the prior approval from the labor authority. Otherwise, you cannot freely to adopt these two special working hour systems.
Yeah. Thank you, Lily. You mentioned several times OT. For those who are not much familiar with the OT, OT means overtime. And we have prepared one of the polls specifically for the overtime. For those who have some experience with employment, either on the side of the employee or the employer in China, you know that it's a very sensitive topic, and it makes sense to pay due attention to it. So I'm now launching our second poll, and I would like to ask you to answer the question about the overtime. And the question is, employee who has worked overtime, whether can be granted the compensation in a day, and that the employee has to agree, or whether it's up to the employer to decide whether it will be compensation by time or compensation by payment. And the third option, no, the employer has to pay overtime in any case. So we are receiving your votes. You can see the results, and in a few seconds we will close it, and I will ask Lily to give comment on the results. Yeah, so I've seen that most of you have expressed already your opinions. So I'm closing the polls and sharing with you. So, Lily, would you like to comment?
Okay, now our result is 74% tick yes, but the employees has to agree, and only 6% tick B, yes, it's up to the employer to decide. Also, we have 19% tick C, no, the employer has to pay overtime. Okay, Okay, I would like to comment further on this question. The overtime payment actually is a little bit complicated. The picture is a little bit complicated here in China because we have the different working hour systems. So under the different working hour systems, the OT rules is different. So let's see the following slides. Okay.
Yeah.
Yeah. I see the following slides may give some ideas here for your better understanding of the OT. So on these slides, this is about the overtime under standard working hour systems. So the overtime, normally the overtime will be triggered on the working days, the prolonged overtime on the working days, and the overtime on the weekends, and also the overtime on the public holidays here in China. So for the overtime, I mean during the prolonged working day or during the national public holiday, the employer must pay the overtime payment to the employee. Even if you have agreement with the employee to say, hi, I don't want to give the overtime payment, how about I give you the equal compensation leave? Even the employee agree this is illegal. So the employee probably will bring this case later to the People's Court, and the employer will definitely lose the case. However, for the overtime during the weekends, under these circumstances, and the employer can say, okay, we can give you the compensation leave instead of the OT payment. However, the precondition for doing so is you have to specify this in your employee handbook, and the employee handbook must be publicized and notified to the employee and signed by the employee. Then you can just say, okay, we can give the compensation leave instead of the OT pay. And for the overtime calculation under the standard working hour systems, for the working day normally is 100% of the basic hourly salary. For the weekend day is 200%. For the public holiday is 300% of the basic holiday salary. So in order to implement these OT rules effectively within a company, so it is suggested to incorporate such internal overtime and leave approval procedure into your employee handbook, so you can control in what circumstances the OT is really required. So you can avoid the employee just do the work there, but you have no idea whether he or she is really doing the OT or is only playing there. Okay. Okay, now, so previously we're talking about the labor contract, the working rights of the employee. Now we come to the slides on the leave rights of the employee. So under the Chinese laws, in generally speaking, the employee can enjoy such kind of leaves like paid annual leave, sick leave or work injury leave, maternity leave, marriage leave, and funeral leave. And for the annual leaves, if the employee's working experience is no more than 1 year in total, then this employee is not entitled to enjoy any annual leave here in China. So if the employee has working experience less than 10 years in total, then he can enjoy 5 days. If between 10 years but no more than 20 years, so it can enjoy 10 days. But if he's over more than 20 years, then he can enjoy 15 days.
Yes, and now we are coming to the second important part of our presentation, and it is the employee handbook. In the first part, we were talking about the contract, labor contract, and focused on some mandatory clauses, an overview on the working hours. Now we are going to the employee handbook, and Lily will explain what the employee handbook is and why it is so important.
Okay. Okay. Now we come to the employee handbook part. There's a, we always been asked this question, why we need an employee handbook here in China and why it is so important. So briefly speaking, internal rules can provide a guideline which will specify both the employers and the employees' rights and duties. So normally, this is very important for the employee because the employee will know what kind of rights do I have in this company and what kind of duties should I perform. And the second point is this employee handbook is actually kind of code of conduct, so the employees knows what kind of actions I can do and what kind of codes is properly can do in this company. And also from the management point of view, if you give a clear code of conduct, and then you can manage the employees more effectively. And the last one is the employee handbook will be a very effective instrument and a proof of the content of employment relation when needed. So normally this will be needed when coming to the termination issue. And we will explain this in more details in the later slides. So the next question is, if we need an employee handbook, then the next question will be, what kind of clauses should I put into the employee handbook? Generally speaking, the law is silent on these kind of things. However, based on our practice experience, we would suggest to incorporate the following key items for your kind of consideration. The first one is the recruitment requirements. Specifically speaking, what kind of requirements or recruitment requirements will be qualified, for the candidates you want to hire. Next one is about the business hours and the overtime things. You have to let your employee know you are working our system here. And the remuneration rules, bonus, and the social welfare systems. Paid annual and any other leaves or leaves approval procedure, and the pension plan, and trainings if necessary. For some company, they may need to train some senior management for the business purpose, but for some company they may not. It just depends. And the general behavior of the employee and the working place security provided by the employer, and what the punishments or discipline matters will be, and this will be closely related with the termination rights of the employer. And also the procedures for you apply for the leavings or the other things, OTs. And at will statement, normally we will have this at will statement at the end of the employee handbook, so to make sure the employee fully understand what is saying here in the employee handbooks.
Okay, so it was a nice introduction to the content of the employee handbook. Now we will pick up some of the chapters of the employee's handbook, and we start with the recruitment requirements. So everybody, most of us understand generally at least understand what the recruitment requirements should be. But what is the practicality in it to have it in written?
Mm-hmm. Okay. So under our China labor contract law, the law says, okay, if an employee during the probation period is proved to be not qualified for the recruitment requirements of the employer, then the employer can terminate the labor contract immediately and without paying any severance payment. So just because of this article, under this labor contract law, we need to specifically put the details, what will be our recruitment requirements in our company. So if the employee is not qualified for any of the recruitment requirements, then you will have the proof to make your termination to make your termination reasonable and legal. Here we would like to suggest the following recruitment requirements. However, depending on the business scope, business model, and the management requirements of a company, you may consider to specify your own recruitment requirements. Normally, we need the candidate should be, if a candidate is a minor under the age of 16, this is illegal here in China. If the employee has not disclosed to the company that he or she has signed a non-competition agreement with his or her previous employer that will affect his or her work for the company, or if the personal materials submitted for the job application are false, or the employee induced the company to sign the employment contract by using dishonest methods which makes the signing of the employment contract contrary to the company's real intent, or the employee is under investigation for criminal responsibilities. So if employee is qualified for any of these requirements, then we will say, okay, he is not complying with our recruitment requirements. Then we can say termination later legally. Yeah. Now the important thing is about the performance of the employee. So the performance result is very important for the employer because he can use this for the laterally for the salary position adjustment or for the legal termination. In our practice, I will suggest the employer to formulate your own standard performance assessment form and make it as appendix to your labor contract to your employee handbook. So about the standards should be very clear and specific and easily understandable by the employee, and also it's subject to the business scope, model, and the position of the employee, and the standards may be quite different. So here we would like to draw your attention is these standards must be formulated by the company and must be clearly understood by the employees and accepted by the employees. And better to put it as an appendix to the employee handbook, because just in case there is a dispute later, then this result will be very clear proof for the employer. In addition to this, the performance result can be the basis for adjust your salary and employee, and also the employer can given a 30 days prior notice to do the termination.
Here I would interrupt you, and I have again, I hope, the practical question. So you mentioned that the written performance assessment can be used as a basis for position adjustments and the salary adjustments. So for example, if I, in my company, employ a team leader, and I still want to keep that person, but I would like to keep him as an ordinary member of the team. How can I do it? Can I adjust his salary, or because he will fight with me? But what are the legal bases? What can I do to make it happen?
Okay, yeah. Okay, this is a very good question. Under the Chinese laws, now is silent on this point. However, it did clearly mention in what kind of instances the employer can legally adjust the position. But normally the position change, the change of the position is linked with the change of the salary. So employees will be very happy if you give a salary increase, but they always complain if you give a salary decrease. And in our experience, we see some companies in their employee handbook, they say, okay, the employer has a right to freely adjust the salary at his own discretion. And they think they put the clause here in the employee handbook and signed by the employee, then can definitely 100% to protect the employer. However, this is not so right. Our suggestion here is, okay, you should use the principle under the labor contract law, which is the equal pay for equal work. And in addition to this, you should have a kind of internal rules and to regulate the salary scope for the different position levels, and which should be made clear to the employee and ask the employee to know these things in advance and accept it. Then when the position changes, you can say, okay, now your position changed from general manager to a secretary. So our secretary's salary is like this stage. Then you can say, okay, now upon this, we can just legally change your salary. So this can be protect the employer at the most extent. Okay. For the performance assessment, normally there will be two kinds of performance. One is the probation and the other is annual. The probation normally is used for passing the probation period or not. For the annual assessment, normally will be used for the salary or position changes. And we would like to draw your attention on the annual bonus things. We will suggest you to say in your employee handbook, like employer has his own discretion to decide to give the annual bonus or not, and how much the bonus will be given. And we don't suggest you to give a specific number about the annual bonus in the employee handbook, which means you have to given as per the rules there in the employee. So I want this annual bonus thing will be more flexible in your employee handbook. And now we come to the rules about the employee, which is about the attendance record filing. I think each company will have such kind of internal rules about the attendance, but the purpose is not just to give the attendance rule there and to ask the employee to follow. The most important thing is you should let the employee know what will be deemed as the absence from work. Because the absence from work, you can say in your employee handbook that this will be deemed as seriously violates the internal rules of our company. So the next thing is the employer has the right to legally terminate the contract immediately without paying any severance pay. This is the most important thing. For the definition of the absence from work, based on the company's business model and your management purpose, you can give your own. And here we just give two examples, like absence without asking for leave or without obtaining approval, or absence after leave without completing the proper procedures for leave extension. Next, we will talk about the confidential and the non-competition. These two are always linked together. For the confidential information, normally it refers to those controlled by the employer or the affiliated companies and specified in the internal labor rules. So normally we will give a scope on what should be deemed as the confidential information in our employee handbook, and how to define and what kind of characters that the confidential information has. Normally it has such characteristics like unknown to public and capable of generating economic profit for the employer, and is specific and can be immediately applicable, and the confidential measures have been taken by the employer. This is a characteristics. Just in case there is kind of dispute, we can give these characteristics to persuade the judge to convince the judge that this is belong to the confidential information. But the thing is, what if an employee breaching a confidential agreement? Normally, in the employee handbook, we will say, okay, the breaching confidential agreement will be deemed as a serious breaching of the internal rules. Therefore, the employer has a right to terminate the contract immediately without paying any severance payment. And in case the employee caused any financial damages to the employer incurred by this kind of confidential agreement breaching. And but the last thing is, in practice, it's very difficult to prove the infringement of such kind of confidential information or trade secret. But you can do something to protect.
Yeah. You have just mentioned that it's that the proof the infringement of the confidentiality information of the trade secrets is very difficult. Could you give some hints or some practical advice how the employer can protect themselves, or what they can do in order to limit the risk that some very important trade secrets leak out?
Okay. I will suggest you to take such kind of measures for the confidential information protection. So you can consider to restrict the peoples who can access this kind of information. For example, for the core technology informations or core business informations, you can only allow the general manager level or the C level to reach such kind of informations. For the department manager, they don't have such access right. And in addition, currently we use the computers or electronic data so frequently for our daily office. So we may consider to restrict to not so frequently use the electric version to generate our confidential information. For example, you can only give the hard copies of such kind of confidential information to the employee he should know, and also you can take records for what kind of employees just taking this kind of hard copy papers from your side. So this can be a kind of tricky method to identify finally is which employee just discloses confidential agreement. This is just a very simple suggestion. Maybe based on the specific your business model, you can figure out your own.
Mm-hmm. Thank you.
Okay, non-competition now is very popular here in China since the new labor contract law issued, and just in recently there is a interpretation issued by the Judicial Bureau. So firstly, we should know what is non-competition. Normally, it doesn't apply to everyone. It's only applied to the senior management staff or technical or the staffs who may have the obligations of confidentiality. And the law says the employer and the employee can freely to agree on the non-competition areas or scopes and even the terms, but the term cannot exceed the 2 years, which means the 2 years is the maximum non-competition period after the termination. And the other thing is how to calculate the compensation payment. If the employee say, okay, I fully followed the non-competition agreement after the termination, what kind of compensation payment amount should I obtain? Before the new interpretation issued, there is no general rule on this part, and so there is a silence on the compensation payment, and then later if there's dispute, and employee can reach a new agreement on this point to continually to perform this non-competition agreement. Under the new interpretation, it clearly says 30% of average monthly salary of the last 12 months before the termination of the employee should be, this is the lowest amount, should be paid by the employer. If the employer fails to pay the compensation payment for 3 months, then the employee has a right to request termination. And the employee also has a right to request for additional 3 months compensation from the employer if this is the employer proposed for the termination first. And if there is a breach of the non-competition by the employee, and the law says, okay, the employee shall pay the liquidation damages to the employer. In addition to this, he should also continue to perform his non-competition liability at the request of employer. So which means if the employer doesn't request the employees to continually to perform, then the employee will be released from this liability.
So now we are coming to the last chapter of our today's presentation, and it is about the termination, which poses quite a lot of troubles to both employees and employers, certainly because of its nature. So we try to provide some guideline how to go through this procedure without or with the less possible pay.
Okay, so termination is very important. We are in China. We often being asked, can I terminate an employer, and do I need to pay the severance pay? This is a frequently asked questions. Whether you can terminate a contract or not is depending on whether your termination reason is a statutory reason specified under Chinese laws. Currently, there are 14 reasons that the employer can use to legally terminate an employee. And for the severance payment, is also depending on the termination reasons. For example, if the termination is made upon the reasons here listed, then the employer has to pay the severance pay. For example, the employer proposed a termination and agreed by the employee. Article 40 of China Labor Contract Law. I will explain here. The Article 40 actually is signs. Okay, if the employee is incapable of current position, after receiving a training or transfer to a new position, still incapable, then the employer can terminate upon a 30 days prior notice. And if the employee is suffered from a illness, is non-work-related injuries, and is still in the medical period, and upon the training or upon a transfer to another new position, still cannot do the work, then the employee has a right to terminate. Also, 30 days prior notice is required. Or if the conditions when the employer and the employee concluded this labor contract changes, and both parties cannot reach agreement, then you can terminate the labor contract. For example, if the law changes and the articles of the major articles of the labor contract cannot apply anymore, so we have to terminate the labor contract. So the next one is bankruptcy. Under bankruptcy, the company still has a liability to pay the severance pay. And the earlier termination, which means before the contract was expired, and if the employer proposed to terminate the contract, then you have to pay the severance payment. And also, if the employer's business license is revoked by the People's Court or by the governmental department, then you have to pay. Also, the contract expires, the employer says, okay, I want to renew this contract with you, but maybe the salaries or the positions is lower than the current ones. And under these circumstances, you should pay the severance pay also. But if you give a higher salary and a higher position, and the employee say, no, I don't want to renew the contract, then the employer will be released from the severance payment liability. So if the employer terminates the contract using any other reasons, will be deemed as illegally termination. The result will be the employer, it will be requested by the People's Court to continually to hire the employee, or will be paid the double rate of the severance payment to the employee for terminating the contract forever. In addition to the termination things, and I think the company should also know for what kind of employees you cannot terminate them. So we list here these kind of employees the company shall not or has not had the right to terminate. If an employee in a medical investigation period or vocational health inspection not done prior to the leave, or if the employee suffers from work-related injury and lose all or partial work ability, or the employee suffers from non-work-related illness and is still in the statutory medical leave period, a pregnant employees and employees has worked with a current employer for a consecutive 15 years and will enjoy the pension benefits no more than 5 years later.
Yeah, it sounds really very strict. So does it really mean that under any occasion and under any circumstances, employer cannot terminate employee? You mentioned right now, even for example, he or she is constantly late for the work, or she is absent?
Yeah, this is a very great question. Actually, we also been frequently asked the same question. The answer is definitely the employer has a right to terminate this kind of employees listed here under circumstances like, take the pregnant employees for example. Most of the companies think they cannot terminate pregnant employees' contract. However, if the pregnant employee seriously violates your internal rules specified in your employee handbook, the employer also has a right to terminate the labor contract immediately without paying any severance payment. So this should be cleared, yeah. And also for the termination from the employer side, the law says the notification to the labor union must be done. Next question is, if the employer should pay severance pay, then how much he should pay? There is a formula: monthly average salary plus the years of service. Monthly average salary, and normally the base is the gross salary of last year. Actually, it should be 12 months, including all extra payments paid in cash. And probably the formal regulation will apply to the employer prior to 2008 if the contract was concluded before that, before 2008. And I think it's also very important for the company to know in what circumstances I don't need to pay the severance payment. In generally speaking, if the contract is terminated due to the employee's fault, like seriously breach the internal rules, not qualified for the recruitment requirements, and so on, then no severance payment is required. And the part-time contract termination is not required. You can just terminate the part-time contract at any time you want. So the last issue for the employee handbook is also very important, is how to validate the employee handbook. You cannot say, okay, we have an employee handbook and I just show to the employee and of course the employee should follow. This is not wrong. This is not correct, because our law says, okay, you must go through the publication and approval procedures. So which means staff must be aware of the content of the employee handbook, and this handbook must be known by all the employees. For example, you can organize a meeting and notify and showing the hard copies to each employee, and you can seek the advice from the employees or their questions or comments on the employee and clarify the issues with them. And finally, the employee should sign a confirmation letter after the employee handbook to specify he fully understand and accept. So only upon these procedures be finished, then this employee handbook will be valid. But there also a question from the employer saying, okay, if employee didn't agree the contents of my handbook, and even I give the explanations, they didn't accept. So they didn't accept. So under these circumstances, the employee's handbook is also valid. Yes, because the final decision is on the employer side. The employee has a right to give their comments, but the decision can be made by the employer.
Mm-hmm. Okay, so we comes to the summary, and if I may conclude, Lily, then if you then have some other suggestion, you are free to comment on it, and we will give few seconds to Lily to review the number of questions, which really we receive quite a lot of. So about the summary. Labor contract shall be in written form and signed before or immediately upon the work starts. It is the safest way and will save the employer any troubles, penalties, additional payments, and so on. Employee handbook is a very useful and practical way how to regulate employment relationship and clarify mutual rights, duties, and procedures between employee and the employer. It should be duly approved, published, signed, ideally as an appendix to the labor contract. And some of the topics which we have covered during today: working time, overtime, leaves, disciplinary measures, terminations are often a source of misunderstanding between employer and employee. and therefore there shall be great attention paid to them. Now we are coming to the last section of our today's webinars, and those are Q&As. Please, those who haven't asked a question yet, I'm encouraging you to go on. We have about 5 to 10 minutes till the end. I would like to remind you that our webinar, the presentation and the recording will be placed on our USME center.org.cn website, so you can download it later on. Questions which will not be answered during today will be answered via email to those who will provide us with the email. So, Lily, can you answer some of the questions which we have received?
Okay. There's a question from our listener is asking OT on working days is 100% or 150%? It's 150% for the working days. For the weekend days, it's 200%. For the public holiday, it's 300%. The next question is about the interns in China. The question is, internship require an employment contract, or is there a specific type of contract for internships? So employment contract, which means the employer has to pay the social insurance and the salary things, and the employee has a right to receive such things. However, for a student is still studying in a school or in a university, she cannot join the social insurance system here in China, so he can never sign an employment contract. And if you want to have something to prove that the relationship, internship relationship, you can just give a kind of a document to say to ask the employee to ask the interns to issue a kind of a certificate document from the university, and to say, okay, our student is now doing an internship in your company, and so please just accept our interns and accept our students, and let him or her doing the internship, and have this kind of introduction letters from the university. And I think this is enough for you to prove the internship. The next question is severance pay. On which basis is severance pay calculated? Means which factors are influencing the calculation of the severance pay. The severance pay is calculated based on the gross salary of the employee of the previous 12 months before the termination. This is the average things. In addition to this gross salary, if you also has any other benefits given to the employee in cash, like the bonus things or the 13 salary given by the FIEs here, this will all be included into the base for calculate the average severance payment basis. But I would like to share with you one thing. For the sick leave salary, we have a statutory rule saying the sick leave is only 80% of the minimum wages issued by the public, by the government. Take the Beijing as an example. The minimum wage is only 1,600 roughly. So if you only pay 80% of this number, then you are legal. So when doing the severance payment calculation, it will be good for the employer. However, you must put this sick leave rule into your handbook, employee handbook in advance. Next question is, if the employee is hired through European company but is working full-time in China, are they subject to the employee country employee laws or Chinese? Well, it depends. If the European company has a subsidiary in China, normally it signs a labor contract with the European company and then second this person to the Chinese subsidiary for work. Under these circumstances, this employee should apply for the working permit here in China, and also sign a local labor contract for applying for the working permit matters. So under these circumstances, the China labor law will apply. However, if you do not have any Chinese subsidiaries, you just send these foreigners to work in China based on the F visa, business visa, or the other visa things, then the China labor law will not apply.
Yeah. Thank you very much, Lily. We have received many other questions, but unfortunately we don't have time to answer them all. So Lily will get back to you later via the email. I would like to encourage you to join our next week webinar, which will be on green building. So everybody who is interested in this topic, please join us next week the same time. As well, for those who would like to have more information about doing business in China, market entry, exporting, labor rules, please visit our website, usmecenter.org.cn. And I would like to thank you very, very much to Mrs. Lily Kao for her time and for sharing with us valuable information. And we both of us hope that it will help to your business go on a smooth path.
Okay, thank you, Ludmila, and also thank all the listeners there. And I'm very happy to share my experience about this topic with you. Thanks again.
Yeah. Please, after the finishing of the webinar, if you can spend a few seconds by the evaluation, which you will receive automatically. So thank you, and have a nice day, and hope to join us in the next occasions.